Hello, my name is Mark Boyer, and this is a follow-up that I told you to stay tuned to this dial. And I wish I had better report, but it doesn't mean all things. You know, one battle was lost, what can I say? Seems that when I went to the courthouse, okay, when we went to Zoe's bail undertaking, we had to file in the Supreme Court, okay, because the lower court refused to rule on failure to, they have no jurisdiction, which means I had to write a really good argument, okay? Now that's posted called the prescription for by law for our beliefs, okay? And it's a very powerful defense using Section 1 of the Charter, which guarantees democratic rights cannot be trampled on. It's a unique defense to the Marijuana Party of Canada, and if it works, everybody's happy, okay? Now, bottom line is, we filed in the Supreme Court, or actually Zoe filed, because I got arrested when I went to file with her on an outstanding issue, and I'll deal with that shortly. So Zoe had to do all this filing herself, because one of the bail undertakings that I have is I couldn't go into the courtroom, because that's where I was arrested. Now, so Zoe goes in and files, and pays the $208 and files for a short leave application on a beautiful defense, and was told to come back at 2 o'clock in the afternoon. And at 2 o'clock in the afternoon she shows up. She waits an hour. She goes before the judge, and frankly the judge is only ruling on whether it's going to be heard in 3 days or whether the Crown wants to take 2 or 3 weeks, which is the normal turnaround for a 1-hour application, okay? It's quite common that it's really common to get a quick ruling. Now, so when she goes to this ruling, this judge tells her that she has no right to use the Supreme Court of BC as her first place to go when there are 2 or 3 other legal steps to proceed before going to the Supreme Court and threw the case out. But, you know, at that level of the court, of a short leave application, the judge had no such right. He just had to rule whether he'd hear it in 3 days or hear it in 2 or 3 weeks. So they really screwed up. Basically, they saw the defense, and it's bulletproof. And obviously, we are not bulletproof, especially to their perverted rules and regulations. As I said, this defense was not recognized, but it's self-evident that they ran away from it because it is such a good defense. So it might be to everybody's best interest to go get a Marijuana Party membership through my website, or go to the marijuanaparty.ca. Now, on the other issue of me getting arrested, now that one I've been working on since I got out of jail over January 1st, just at the New Year's. I wanted to file against the Attorney General for a series of reasons. One, he classified me as an MDO, and he had no such right, okay? It took me 2 months of filing paperwork and doing activity, political activity, to get to a forensic review board, which said, agreed that that a crime had been committed under the Act, and that the enforcement was now under the jurisdiction of the Attorney General. And so I now had a valid reason to go see my Attorney General. Now, when I got out of jail, there was only one bail undertaking left, and that was that I couldn't see the Attorney General. And on their paperwork, it said it expired on 4/23/2010. It was a 2-year probation. Now, that's what my paperwork reads, that's what their paperwork reads, but that's on this one way of recording data. Now, when you go to the registry and you find out what court date it actually happens, which is, you know, through another registry, you find out that it happened on 3/23/2007 or 2008 was this ruling of a 2-year prohibition order of failing to go, of not going to an attorney general. So there, the math is off by a month. Now, I only came aware of this about 2 months ago, really. Okay, it just became, wow, look at this date's off. Now, by this time, I had this court date to appear before Judge Kitchen in criminal court saying, Your Honor, I've got this beautiful reason that I have to go see my Attorney General because the act has been broken and I have to go see the Attorney General because that's where they're telling me I have to go to get remedy to fix my problem. And the judge wouldn't do it because, Judge Kitchen wouldn't do it because he thought it was too important a ruling. So he sent me to Judge Romley, the asshole pervert of the law, who did the original violation of his fiduciary trust, which is a 14-year event. 14-year offense. Now, I had to appear before him, and when I appeared before him in, 800 Smythe Street, he tells me that, or Robson Square, and he tells me that I don't have a valid reason. It's not important for me to see the Attorney General. Now, and he says you can wait the 2 weeks, or by this time it's 2.5 weeks, to see him just like any other person can, okay? Now, so basically, I have 2 rulings that they don't want me to see the Attorney General when they actually are pissing in the wind because the dates are wrong. And I knew it, but I was testing how their heart was, okay? And the reality is how I really tested their heart is I walked into the Attorney General's office on the 22nd of April, okay? And said, hi, I'm being a nice guy, and said, this is the first day that I'm free man to do this, and I'm serving these documents on the Attorney General. I'd like to have an appointment with him, and left, okay? Now I went back on May 7th, which is 2 weeks later, and then this time I was a little more forceful, and I went, hey, I need to see the Attorney General, and they got in my face, and there was a little more altercation, and I filed more papers, and court documents say that this is the day they actually pressed the charge, which is basically, as I said to my my probation officer, am I wrong? You know, the worst I've done is civil disobedience, doing an act of nonviolence or almost nonviolence in order to create attention to a bad law or a bad set of laws. Okay? And that is the definition of civil disobedience, and that's what I did. Now, the Crown pressed charges on me, and they gave me a bail undertaking that I can't go see the Attorney General again because I was off by a day. And as I said to my bail supervisor, I says, I was off by a day, they were off by a month, and they are definitely using the law as an instrument of punishment because nobody wants me to see the Attorney General because the Attorney General would have to press charges against the previous Attorney General under the fiduciary trust of his oath. And we would have one step closer to returning paradise on earth. And what can I say? I'll have to carry this on in another video.